The title of this video is Maximilien Robespierre, What He Can Teach Us About Evaluating a Plaintiff's Case. Maximilien Robespierre was a lawyer and a statesman. At many levels, he was the ideological father of the French Revolution, a principal in the Jacobin Party. And he had a lot to do with starting the French Revolution and ultimately executing the king and the Reign of Terror. And one of the things that he propounded as a lawyer, and this is a man who made over 900 speeches, was a restriction on the rights to challenge the order of execution. Well, ultimately, in terms of the Reign of Terror, notwithstanding that he had been one of the central figures in getting it started, he was arrested and guillotined on July 28th, 1794. He started something and it finished him. What does this have to do with litigation? Well, I always recommend to my clients that before they initiate a plaintiff's case, whether it's with a contingency attorney or in particular, if it's with an hourly attorney, that they evaluate it very, very carefully. And I got a referral in on a case where this particular individual, a medical doctor, was involved in a dispute over a real estate sale. And the doctor had spent over $380,000 in litigation to his hourly plaintiff's attorney, who repeatedly told the doctor that he was the best attorney that he ever would find, only to lose the case. And not only did the doctor lose the case, but the doctor was ordered to pay $400,000 in attorney's fees to the other side. Well, what's wrong with this picture? Well, what's wrong with this picture is that fundamentally, when you have someone that's billed hourly and you go to the plaintiff's attorney and say, hey, do I have a great case? Sure you do, because hourly attorneys are trained to tell you they have a great case, because they don't make or lose money by whether they win or they lose. They make money by whether or not they give a timesheet and they get paid. And you get both sides, the defense and the plaintiff, saying, you're going to win. You have a great case. And I handled the appeal. As I delved deeper into the case, it was very apparent that this particular attorney was anxious to go without having done due diligence. In fact, there was a provision that said if you wanted to recover attorney's fees, you had to mediate first. And I asked my client, were you told that? Did the attorney warn you that if you wanted to get attorney's fees and you think it's a great case, you have that provision? He said, no, not at all. The writing was poor. The analysis was weak. And basically, this attorney had put this doctor into a dispute with no desire to cooperate with the other side, to really narrow the issues, or otherwise proceed in a professional manner that restricted the number of issues that were presented to the court. And the court was not very happy by the bickering between the attorneys and the obvious desire to expand the number of trial days. What's the proper way to evaluate a case? Well, as a performance attorney or as a contingency attorney, my survival economically depends upon accurately and intelligently evaluating the case, the collectability and the strengths and the weaknesses. And that's free. People come in and they lay out the case. And what do you look for? You look for collectability. Is this a defendant where you're going to ultimately be able to collect the money? You look at the paperwork and how the parties documented their deals. And you look at the part outside of the four corners of the documentation. Who's the good person and who's the bad person here? You meet with the client to determine whether they're credible, and then you give them your evaluation. And the final thing I say when I'm talking to a client about a prospective case is, you don't have to trust me because it's my money too. And the problem with proceeding with an hourly attorney on a plaintiff's case is a lot of times the clients are wary of talking to the attorney because the conversation will move into pleasantry, and yet they're paying tens of dollars by the minute in order to chit chat about basketball. So what you need before you start the reign of terror is careful analysis of what the risks and probabilities are. The other thing that you need to do is, as an attorney, it is your obligation to explain to the clients the risks and the burdens of litigation. In particular, when there are attorney's fee provisions that are going to go back to haunt somebody, and leaving everything else aside, clients routinely, and not always, but almost always, underestimate the time and energy it's going to be in litigation for multiple years, in particular when they're against an angry and well-financed adversary. Get your case checked out by a contingency and performance attorney. Be wary of hourly attorneys that want to take a plaintiff's case and aren't intelligently and accurately describing all the risks.